All right, let's go to issue number 3, non-competes. And I just, for some reason, I like this image for non-competes. I'm not sure if this is supposed to mean that these guys, these boot camp soldiers, are competing with each other, or if this is like illustrating trying to understand the Texas non-compete law, and how difficult that is. If you've ever had a non-compete issue, you start with the non-compete statute, but there's a lot of case law interpreting that statute, and for some years there was a lot of uncertainty about whether non-competes were enforceable. The Texas Supreme Court has moved in the direction of making it simpler and easier to enforce non-competes, as you probably know. So I won't go into great detail about that whole history. I'll just remind you there are 2 things you need to have an enforceable non-compete. One is that the non-compete has to be ancillary to an otherwise enforceable agreement. And that's where for years we had a lot of back and forth in the courts about what does that mean? And eventually where we ended up is the most typical situation for a non-compete is where you have an employment agreement that has a non-compete tied to a confidentiality agreement. That's the most common situation. There are other kinds of non-competes, but that's the one you find most often in departing employee scenarios. What the Texas Supreme Court has said is that in that situation, if the agreement provides that the employer will provide confidential information to the employee, and sometimes they'll mention specialized training also. That often goes along with confidential information. But if the agreement says that, and if the company actually follows through and provides the promised confidential information, then the agreement will meet this requirement of ancillary to an otherwise enforceable agreement. So that's been simplified. The second part of enforceability is reasonableness. The non-compete has to be reasonable in time period, geographic area, and the scope of activity that you're restraining. So 3 things that have to be reasonable. And here is where you really, the statute itself is going to tell you that, but it's not really going to tell you how that applies. That's where you really need to look at the case law to see how Texas courts have applied reasonableness in those to those 3 issues. I'm going to simplify that for you and boil it down to another one of my laws. So I call this Wolfe's first law of non-competes. And I'm going to sum up all of Texas non-compete law in just 7 words. And those 7 words are, you can't take your clients with you. You can't take your clients with you. Now, that's a generalization for sure. And there, of course, are going to be exceptions. But in most cases, that's where you're going to end up after going through the whole analysis of the non-compete. Why is that? Well, one reason is that Texas courts have said that an industry-wide exclusion in a non-compete is generally unenforceable. What's an industry-wide exclusion? That's where the non-compete says that the employee cannot accept employment with anybody in the company's industry, in any capacity. That's too broad. Texas courts are not going to enforce that. There are opinions that have said that's too broad. It needs to be tied to that employee's particular customers, the customers that employee came into contact with and had relationships with at the company. That's what it's reasonable to protect. And so that's part of where I get this Wolfe's first law, and I say you can't take your clients with you. If the employee is trying to take his customers with him from one company to another and has a non-compete, that's probably not going to fly. On the other hand, if the employee is just going to work in the industry, but is not taking customers from the previous employer to the new employer, that's probably going to be allowed. Again, it's a generalization, but I think it'll tell you the result 9 times out of 10. So that leads to my practice tip. on non-competes. Well, I've got two. The first one is, it goes to this ancillary to an otherwise enforceable agreement issue. And the tip is to evaluate the confidential information issue early. Especially applies if you're trying to defeat the non-compete. If you're the second employer or the employee's counsel and you want to argue against enforceability of the non-compete, one argument you could make, if the facts support it, is to say, well, my client, yeah, she got information. I mean, every employee gets information from a company, but the information she got really wasn't confidential. If you can make that argument, and if the facts back it up, then you've got a case that the non-compete is unenforceable because it is not ancillary to an otherwise enforceable agreement. And I've made this argument. I made it in a case where I was able to make the argument partly because one of the employees in question basically had all his customers before he even came to the first company. So he had brought his customers from some other company to the first company, right? Didn't get any additional information about them, and then left that company and went to another company. And so the argument was he didn't really get any confidential information. But in most cases, that's a pretty tough argument to make. And one reason for that is the Texas Supreme Court put a little comment into one case. This was the Alex Sheshinoff management case. And that's the case where the Texas Supreme Court really tried to simplify enforcement of non-competes. And they said, we don't really want to get into these technical issues like the true level of confidentiality or the true degree of confidentiality of information. They said, we don't really want to get into that. It's enough if the employer provided some confidential information, that's enough, at least for this ancillary requirement. So that's why I say you need to evaluate this issue early, because this isn't an argument. If the facts are not going to be strong in your favor, then don't bother with making this argument. It's too hard to make. So, and there's no point in making it half-heartedly. If the employee gets into a deposition and is pressed hard on this, and typically the employee will be, and the lawyer's saying, okay, so you're telling me and the jury, you never got a single piece of confidential company information in the entire 7 years you worked at this company. It's going to be hard for the employee to say no. Now, if you're going to take a position that the answer is no, you need to prepare that employee to say no and to stick to that and to say why, right? I mean, if that's your case, then prepare the employee. But like I said, in most cases, that's going to be a tough argument to make. All right, second practice tip on non-competes. Understand the client's business plan. What I mean is, if you have an employee leaving a company and going to another company, what is the plan for what the employee is going to do at the second company? If the plan all along was, hey, you've got this great customer base and this great book of business, you're just going to move it over to the second company. If that's the plan, you're going to have a harder time. That's going to be a tough issue, right? On the other hand, if the plan is no, I see this fairly often. An employee will leave one company, go to the other, and tell me, no, I'm really not looking to take any of that company's customers. They can keep their customers. I'm going to go look for new customers. If that's the plan, then you're going to have an easier time if you're defending against a non-compete plan. And of course, sometimes you need to, part of your role as the lawyer is to help the client decide what the business plan should be. They might have been thinking it was one thing, but they may need to adjust and make it another. All right, now the case I'm going to recommend to you on non-competes is a case called Republic Services versus Rodriguez. The photo here, that's a photo of one of the offices of Republic Services. This is a legal services company, so they do stuff like court reporting, process serving, records retrieval. Most of us have probably used an outside vendor like this at one time or another. So they had an employee who left, and was sued for allegedly breaching her non-compete. The employee filed a motion for summary judgment saying that the non-compete was unenforceable. And the employee said it's unenforceable for two reasons. Number one, the information I got wasn't really confidential. You could obtain that same information from public sources. Same argument I've been talking about. Number two, the employee said, this non-compete is an industry-wide exclusion. It bars me from working for any competitor, and that's too broad. And the trial court judge granted summary judgment for the employee that the non-compete was unenforceable. All right, but that was not the end of the story. Case went up on appeal. Houston Court of Appeals said, no, sorry, employee, that's not going to work. On the confidentiality issue, there was testimony from the employee admitting that, yes, she had access to invoices, to company financial information. She received training on their software. She had enough access to the company's internal financial information that the court said, that's confidential information. And just like the Sheshanoff case said, we're not going to get into how confidential was it, how valuable was it. And remember, when we get to trade secrets in a minute, but it doesn't necessarily have to rise to the level of a trade secret. So the employee lost on that issue. Second issue the employee lost on was this industry-wide exclusion issue. Okay, now why did the employee lose on that? And this is where in this case, the court took a pretty narrow view of what an industry-wide exclusion means. In my view, probably too narrow, but that's just my view. The court looked at the non-compete, and it didn't say, employee, if she leaves, for 1 year, may not work anywhere in the legal services industry in Harris County. It wasn't like that. It didn't identify the industry. It said something to the effect of, the employee may not go to work for any competitor of company in Harris County for a certain time period. So it was specifically tied to competitors of the company. And the court reasoned that that's not an industry-wide exclusion because the first employer had offered evidence that there were companies in that industry that were not its competitors. So in other words, limiting it to competitors made it narrower than the entire industry. And the court agreed with that argument. To me, I think that may be too narrow a view of the industry-wide exclusion rule. There are other cases that interpret that rule more broadly. But anyway, be aware of this because the industry-wide exclusion issue, I would say, in most non-compete cases, that's the biggest weakness for the employer who is trying to enforce the non-compete. When I see non-competes, I'm always looking for what's the defect in it, and that's probably the most common defect is that it runs afoul of this industry-wide exclusion requirement.